All right, thanks for your patience. We are now streaming live, so we will go ahead and begin. This is the regular meeting of the Electronic Records Working Group, meeting via Zoom web meetings and YouTube Live, April 5th, 2023 at 10 a.m. We will start with our customary roll call, and I will read off our members. If you would unmute and indicate your agency, that seems like a very effective way of doing roll call. And then I will read off our guests. So Graham Gray.
State Auditor.
Tammy Satterley.
Sorry, KCTCS. Thank you.
Glenn McInich.
Here and formerly KDLA.
Mark Manley.
Here on behalf of Attorney General Daniel Cameron.
Rob Hill.
Rob Hill, KDLA.
Mark Pulliam.
Legislative Research Commission.
Jeremy Foster.
Secretary of State's Office.
Shamara Jackson.
Here, Lexington Fayette Urban County Government.
We've had a couple more join. I'll go ahead and read off the guests, and then once our other member has joined, I will have her. I will announce it. But our guests are Joe Isaac, Drew Preston, Heath Reynolds, David Atha, and Nicole Bryan, and Catherine Giles and Sarah Garrett, all from KDLA. We're also joined by Amy Benson-Haver and Amy Benson-Haver, formerly of the Attorney General's Office, and Jim Cundy of Jefferson County Public Schools. I see that Lynn McCroskey, you've joined us. If you could turn your camera on and also unmute and indicate that you're here by saying your agency. Which may be having issues. I'll keep watch on that. We do have a quorum, so we will get started. Our first agenda item is the approval of the February 1st, 2023 meeting minutes. If everyone had a chance to look over those, did you notice any issues with them? Anything you feel was omitted or incorrect? With that, do we have a motion to approve?
I'll do a motion.
Thank you, Tammy. Do we have a second?
Second.
All right. We will consider those minutes approved. On to announcements. I don't have, we're quite busy with projects and everything. Most of my announcements are staffing related. We are currently holding interviews for our quality assurance specialist who looks at microfilm and digital images that have been made typically for the local records grant. We have a few that come in that are non-grant, but it's a integral process, and it's been vacant for some time, so it'll be nice to have someone on that process all the time. We are going to conclude interviews this week, and this week is just chock full of interviews for this position, so very optimistic we're going to get someone good for that. And other big news, interviews have concluded for our commissioner slash state librarian. That is all I know, other than we hope that we can make an announcement in early May for just who that might be. So that'll be big, and that's coming up relatively quickly. So that's going to be an exciting time for KDLA. That is all I had for announcements. Moving on to item 3, new business. Would anyone in the group like to unmute and offer any new business for discussion this meeting? Okay, not a problem. I see that Lynn McCroskey's with us. Could you say what agency you're with for the roll call?
Yes, COT.
Thank you. All right. So item 4 is discuss policy memorandum 2023-01. And I'm going to give the floor to Catherine Giles to explain. And I hope you all had a chance to look at it. But Catherine?
Some of you might be aware, or some of you might not be aware, that permanent born paper records must remain in an iReadable format for their life, so forever. That includes microfilm, that includes like photographs, film photographs, and then obviously like paper records. We have a policy in place that people can apply for. iReadable exemption. Agencies can apply for an iReadable exemption that basically allows them to maintain those born paper records in a digitized format instead. We have worked to update the policy memorandum slightly. One, we had a vote from the commission to make sure that local government agencies could apply for this iReadable exemption. And we've also just kind of added some language to make it clear that this is for permanent public records as scanned images. We added some language about the transfer of records, that the state archivist may require the transfer of those iReadable records into the custody of the State Archive Center. We clarified that the iReadable exemption does not replace or substitute the requirements of KDLA's local records grant program grant, or other funding resources regarding preservation. So those are the only like major additions we made. However, since the policy does outline technological requirements for digitized records to be maintained permanently, we wanted to present it to this body to make sure that those technological requirements still hold up, and that there's nothing else that needs to be revised. And if there are any questions, let me know.
Hey, Catherine, this is Amy Benson-Haver. I just wanted to ask you, will this be a document, if we haven't already, is this a document that the advisory committee will review?
Yeah, we can present it to the advisory as well. It'll ultimately go to the commission, but it's a document incorporated by reference. So after those committee approval stages, then we'll be submitting it for revision.
Okay, thanks.
Catherine, this is Tammy from KCTCS. And as you know, we have quite a bit of exemptions that, we have applied for and have been awarded. So what are the technology differences?
There are no changes to the technological requirements. So we make a lot of references to kits, basically saying that certain documentation shall conform to standards that are already established in the kits document. There's already something about resolution and grayscale, having a backup of the digitized copies, making sure that whoever is involved in the preservation of these digitized records, that there's some kind of training in place. So I will say this policy, I mean, I think intentionally, and I don't know if actually if Jim Cundy can speak to it or not, but I think it's intentionally a little bit generalized. That way, as like technological formatting and requirements and minimums change, we don't actually have to change the document a whole lot.
Yeah, I think this is Jim. Yeah, that's a fair assessment, Catherine. When we wrote it, at least the last time we wrote it, we were trying to be not vague, but general, so that as you say, we wouldn't have to revise it every year.
And with kits being included, obviously kits can't, well, I won't say obviously, someone else can correct me if I'm wrong. I think kits is regularly reviewed or can be regularly updated with those like DPI requirements for scanning or scanner recommendations and that kind of thing.
All right, thank you.
So in reviewing this document, we are just asking, like, is there anything that needs to be added to the application process? Is there anything that needs to be clarified further? Or does this body think it's fine?
I mean, I'll speak for one because we just went through this process ourselves, and I think the revisions are just fine. And I think the way it was just fine. It's basically checking all the boxes to make sure you're ready to go before you do it.
Mm-hmm.
Yeah, and as Catherine can attest, as someone who has done this, I have done this quite a few times. We don't just point the agency at this document and say good luck. KDLA works with the agency in question, and I know Jeremy can attest to that, and probably Tammy too. So this is the guidelines, and it's something that both agencies work on together for further elaboration and customization. Yeah, it is generalized, but it becomes a lot less so once we see what the agency in question is working with.
Are there any other questions or comments about this?
Would to bolster the argument for these changes, I think I would like to put it to vote among the voting members that we, as the working group, accept these changes. So I'm going to put it to vote, but all in favor of the recommended changes to Policy Memorandum 2023-01, well, Policy Memorandum 2010-01 to 2023-01, please unmute and say aye.
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 Would any opposed please say nay? All right.
Thank you very much.
Thank you, Catherine. I think that's going to be, it's already an incredibly useful document. I think it's going to be even more useful with these changes. Now, the next agenda item, we'll move right along to discuss updates and possible retirement of some previously authored guidelines materials. I didn't know for sure if we'd be discussing the guidelines in this meeting, but we did get advisory feedback, so I'm excited to discuss our guidelines. But I would like to discuss this working group guidance prior to that. And the amount that we work on this today is really up in the air and up to you all. But I was wondering if anyone had a chance to review these, and also if you have a strong opinion of what to tackle first. in terms of updates. I think it's fairly clear what might be displaced by our new guidelines when those go live, but I'm just going to open the floor to any thoughts on previously authored and approved electronic records working group documents.
I believe that electronic signature record keeping guidelines need probably as much updating as anything. The technology has advanced tremendously, and so I would say that that's a place to focus. But in the meantime, we need to leave up what the guidelines were before.
Oh, agreed. I think that the many of these are strong. I was reading the guidelines for responding to open records requests for public records in a database this morning. And much like the policy memorandum, we just looked at it as general enough to carry forward, maybe with a little tweak. So I think that's what we're going to be looking at with some of these. The 2015 guidelines for managing social media records in Kentucky is also very strong. And I see that remaining a standalone document because it doesn't quite get to, we touch on it in the guidelines, but the social media, I believe, should be a standalone thing continuing. Anyone else have any observations about these documents? Okay. So this is very much to get kind of a plan of work. And I think I agree with Glenn in terms of the first are the guidelines that we're currently working on. I think the first one we could stand to update and punch up a bit is the electronic signature record keeping guidelines. So we do have two guests, and I'm eager to talk about the advisory comments on the guidelines we're currently authoring. So between now and the next meeting, outside of the group, I'd recommend anyone interested, and hopefully all voting members can look at this electronic signature record keeping guidelines document, and we can reconvene next month. It's already on the calendar with our thoughts on it. So unless anyone has any other observations or anything you want to dig into with these previously authored documents, I'm going to go ahead and proceed to the next agenda item. Okay. Well, thank you. Next agenda item 6 is discuss advisory committee notes on the guidelines for managing electronic communications in Kentucky government document. And we have two guests from the advisory committee here, Jim Cundy and Amy Benson-Haver. Looking for the marked up one I sent to share it so we can discuss it better. Here we go. So I do want to ask Jim, did you come prepared with any comments, or did you want to just comment on it while we're doing this?
I'll just comment as we go along, Derek.
Okay. I wanted to open the floor to you because you had to miss that last meeting or the advisory, and I am interested in every member's feedback. So they didn't quite come in the order that they appear in here. We jumped around a little bit, and some kind of pursues other things. I think a major one that Amy pointed out is Kentucky state and local government employees and officials as defined under this KRS. That KRS actually, it defines a public agency, but not government employees and officials. And it's a terminology thing, but we want it to it looks silly if someone goes to that statute and looks for what we are winding up to in the main sentence, they're not going to find it. So Amy proposed Kentucky state and local public agency employees and officials in the very first line. I think I'm in favor of that, but I want to hear if anyone has any other thoughts. So with that said, on this, I will go ahead and fix that live then. There was also some talk of for reducing ambiguity and staying consistent where we refer to government employees, giving it the same change in verbiage. And just say, instead of government employee, say state public agency employee in the state section, local in the local section, and probably this again in the following sections that are for both. That
if I may, where you place that, to me, that doesn't read correctly. Employees and officials are not defined in 61-870. It defines public agencies. So you're saying public agency employees and officials as defined under the statute, but they're not.
Right. How about state and local? Yeah, it's a tricky one because the public agency is what is defined. Employees and officials of Kentucky state and local public agencies as defined.
I think that works. This is Amy. I think that works, Derek.
You agree, Graham?
Yes.
Or want to see it written? I will. I think it reads better that way too. Employees and officials of Kentucky state and local public agencies as defined under, yeah, that's just a better opening sentence anyway. So before we move on to any other, one suggestion Amy had, and it is just a suggestion, is the title Guidelines for Managing Electronic Communications in Kentucky Government. Government is, quite vague. I mean, I don't have that big of an issue with the current title. She suggested for continuity's sake and clarity in Kentucky state and local public agencies. Or I think that could even be shortened to public agencies. If, because I mean, yeah, public agencies is made up of both the state and local. So I want to hear your thoughts on that. I'm okay with keeping government, but I'm also okay with public agencies.
And for what it's worth, Derek, this is Amy. I'm also comfortable with Kentucky public agencies. I think the biggest questions sometimes
Oh, you're cutting out, Amy.
I'm fine either way.
Okay.
is just to understand whether they should dive into it to see whether or not it applies to them. And this way it's kind of broadly worded. Government really is a fairly nebulous term. So I like your suggestion for just in Kentucky public agencies.
I agree.
Okay.
I would also say public agencies is much better because we have a lot of quasi public agencies that are not considered part of the government that this would apply to also.
Oh, yeah. Very good.
Yeah, I agree. Public agencies sounds good.
Yeah. Yeah, I like that. So unless anyone is very opposed and would like to tell us why, I think that is a nice title. Okay.
Before you move on, since we're already up there, if you want to highlight the date as a reminder to update it to March, since we're not going to be in October.
Oh, yeah.
I guess it's April, not March.
Well, and it's a new year as well. Very good. I don't know who all had the chance to watch the recording. That is a nice feature of streaming these. Glenn saw it. So we know a lot of the sticking points, or I wouldn't even call it a sticking point. The observations, the constructive feedback were about what was our sticking point, and they were able to offer some ideas about how to get past it. And some that I sort of agree with. As it reads now, our statement about the public business on a personal device, we say KDLA discourages the use of private devices and accounts to conduct public business. Doing so can bring about legal complications and make it more difficult to manage public records. That is what we cooked up in our previous meeting. Barbara Teague from the advisory committee said maybe insert another statement that messages pertaining to public business on a private device are public record, because that part's not being disputed. And then
I would not agree. I do not agree with that statement.
I would dispute that.
Okay.
Judge Wingate, in his opinion, I'm not going to belabor it, but he said point blank, the court finds that text messages and other forms of communication sent or received on private devices are exempt from disclosure under the Open Records Act and general privacy concerns. So I don't think that statement would be accurate. You could say it might or possibly could or something, but I don't agree with it as written.
Okay.
Yeah, and I would just point out that the phrase public business actually doesn't appear anywhere in the Open Records Act. That's, I guess, created over time from previous open records decisions, but the actual act itself does not use the phrase public business. And so that's kind of a nebulous term that we're using here anyway, that's not defined into anything. I mean, the act says if it's, created by, in the possession of, retained, or used, those are the words that we use. And so even looking at this again with the moniker of conducting public business, that's in of itself a nebulous term. And that's what gets us into this whole thicket of issues as to what does that even mean?
Mm-hmm.
it's, it is way beyond to say the mere fact that a data point in the world talks about public business, therefore it is a public record subject to inspection, is a broad claim that the Act does not support.
Well, I will tell you, Mark, this is Amy Benson-Haver. Again, you're correct, obviously, that the statute itself does not define the term public business, but the Supreme Court of Kentucky has defined it in Yeoman versus Commonwealth.
Under the Open Meetings Act, which is separate.
I thought we were talking about the Open Records Act.
Open Meetings Act is a Yeoman case. The Open Records Act.
Right. But public business is public business. I mean, again, in either context, if it's a
No, it's
matter
not.
of,
They're separate acts. The Open Meetings Act is separate from the Open Records Act, and the Open Meetings Act specifically says public business. That's why Yeoman refers to public business.
I understand that that case arises in the context of an open meetings dispute. I think the definition of public business could apply universally in both contexts. We don't need to argue about this because the truth is it's also been cited in open records decisions, which obviously the current Attorney General does not feel constrained to adhere to. But I will say that I think that's a workable, albeit not a statutory definition of the term public business. But listen, we don't need to argue, but that was Barbara's suggestion, not mine.
I think that if anything, I would be more interested in massaging this about the phrase public business, because it's not in the Open Records Act. And I would dispute any declarative statement that says just because you discuss public business on a private device, that it is therefore automatically a public record.
And I don't think there's any suggestion here. I mean, again, Barbara's suggestion was one that I thought there might be some issues with, since this issue is currently in the courts. I was fairly confident that that would not fly with this group or the commission, since the issue is currently in dispute. But I also think that, again, public business is defined. I understand what you're saying. I think it is that definition of public business has been cited by prior attorneys general, understanding the view of this attorney general that he is not constrained by that interpretation of the law. But what is it that the court says? Any matter on which the public agency has the authority to take action. In other words, if you're talking about UK football, you don't have the authority to take action. If you're talking about a tax increase, you do, if you're depending on the agency. So any matter over which the agency has the authority to take action, or any matter on which the agency has the authority to take action, kind of makes perfect sense in both contexts and has been cited in both contexts. But I hear what you're saying, and therefore I'm not wed to anything that suggestion of Barbara's I knew would create some rancor. So I was not necessarily, and in fact, I think I expressed my concerns about it being at this point something that might raise some hackles.
Yeah, I want to clarify. We provided this to the advisory. They had never looked at it before. So this was just their initial thoughts. The Archives and Records Management Advisory Committee, which is kind of a step before our commission. So this is a lot of archivists and records managers and this is from essentially how a lot of folks in our field think about this. So that was one of their observations. They said instead of like KDLA discourages, sounded like the reader has a choice in the matter. It seemed like a soft statement. I said, well, we started off with kind of a more firm statement and walked it back because of the current legal proceedings to this. And I just want this document to get out there for all the help it could provide people, really. And I'm comfortable waiting for a decision before we change it at all from what it currently reads. What KDLA does, I mean, we do exactly what it says in the highlighted part there. We discourage conducting work, government work, to get away from public business. I mean, via private channels.
And I would agree with the term discourage because it's actually not unlawful to do that. There's no statute that actually said, and maybe that's something that needs to be brought to the legislature's attention for an act that was designed in a paper world when we now live in a digital world. But as the act is currently written, it doesn't actually say that that's an unlawful thing to do. And so, I mean, it goes against the spirit, it goes against the purpose of the entire thing. But is it like actually illegal?
I don't think anyone said it was illegal.
And so, but that's the thing. That's why you can only discourage it. You can't say it's unlawful. You can't say thou shalt not do it because there's not a law that actually says that. And so I think discourage is the appropriate word because, you know, when you do this, you're avoiding the spirit and the purpose of the act, but you're not actually violating it, which is a loophole in the act that should be addressed by the appropriate body. But that loophole hasn't actually been fixed by that body.
Oh, I will say, and again, this is Amy Benson-Aver. I would like to point out that the Open Records Law from its inception has defined a public record regardless of its physical form or characteristics. In, I guess, envisioning this possibility that somewhere down the road we would morph into an agency, to a state that was relying more heavily on electronic record keeping. The bottom line is it does talk about regardless of physical form or characteristic. So it doesn't necessarily limit itself from its inception to hard copy records. And I think that, to be very honest with you, is one of the reasons that KDLA has always been in the forefront of addressing and proactively trying to deal with electronic record keeping as standard record keeping in Kentucky. And in fact, KDLA led the charge in 1994 to have it made expressly clear in the law that electronic record keeping is no different than hard copy record keeping. The previous law, prior to 1994, the Public Access to Governmental Databases law was as close as we had to anything officially recognizing the status of electronic records as public records. That was repealed in 94. KDLA led the charge to ensure that electronic records were expressly made a part of the act. So there's some history here, but there's little doubt in my mind. Well, again, electronic record keeping is clearly contemplated by the statute from its inception because it specifically speaks to regardless of physical form or characteristic.
I should maybe rephrase to say I would agree that electronic records can be public records and that the act can encompass electronic records. But where the act defines public records, it defines it in terms of property rights, who actually owns it, who is the possessor, who is the owner. And when you have a mobile device that's in your pocket walking around, like who owns it? Who actually owns the device? I mean, and so yes, electronic records can be fluid. More people can access them. It's kind of harder to determine who actually owns an electronic record of which there could be millions of copies versus one book on a shelf somewhere. But the reality is that private devices, I mean, we call them private because of the ownership and the property interest. And so, you know, I think that we spent a lot of time on this sentence. In fact, that was most of our interactions in the previous groups. And, you know, other than maybe massaging the phrase public business, I don't think it needs to be changed.
I would agree with that. And I would note too that even though I saw the comment that looks like it's giving people a choice, that's not the point. The point is that KDLA lacks the authority to tell employees of other agencies what to do. KDLA did not hire them. They cannot fire them. They cannot pursue disciplinary action. So KDLA cannot tell an employee at another state agency what to do anyway. So all it can be is a recommendation, something like this. KDLA discourages. They cannot mandate.
I'd like to interject. This is Glenn McInich. That this is just a warning This is not a statement of legality in terms of the public records laws. It's a warning to people that if they do use private devices and conduct public business, they are open to a lot of legal ramifications. Now, and that hasn't been settled yet, whether or not the law would support some kind of sanction with regard to misuse of these messaging records. But it's a warning. So I would stick with the current language. We can't really go beyond it, but we need that in there to make people aware that it is an issue.
Yeah, I think we did an excellent job in this group of massaging it, working it to this point, the point that it's currently at. I think we were all comfortable with it. I just wanted to present essentially the people most of the folks in the advisory had not seen this document, and this was just their first look at it, and these are their thoughts. But they're also just recommendations or observations. So I would like.
Well, Derek, can I just mention, I'm not sure I see the suggestion that I made about the possibility, and again, just a possibility of a more simple declarative statement that use of a private device to conduct public business implicates open records, open meetings, and records management laws. Implicates, meaning basically it could have some implications for any one of those laws. But again, based on what I'm hearing, we're not willing to basically be as, I view these as guidelines, as best practices. So at this point, I think the idea that people are on notice that use of these devices, private devices, to conduct public business, however that may be defined, implicates any one of these three laws. If you had a serial meetings by private email to discuss public business with which the agency was charged, then you might have an open meetings violation. It implicates open meetings. If you had records that were a private device emails relating to public business that were prematurely destroyed, and it was later determined that they were public records. I mean, this is going on all over the country right now. Anyone who's on, reviewing states across the country are dealing with this issue of premature destruction of what in those states is clearly established public record created on a private device. So you have multiple laws that are implicated by the use of a private device to conduct public business. My suggestion, again, Barbara's suggestion, I'm looking at this on my phone, so I can't really see it, but I will say that I remember the discussion of Barbara's. I was concerned that might be a bridge too far, but I also felt like to state simply and declaratively that use of a private device to conduct public business implicates the open records, open meetings, and records retention laws in no particular order. We can put them in any order you all feel is appropriate. I feel like the simple declarative statement, it does implicate those laws. It may be that it's ultimately determined that they are not public record. They do not violate open meetings. They do not constitute premature destruction of public records, but it has to be something that is implanted in the brains of people who are doing the public's business. That was my suggestion. I don't see it here, but then I'm looking on my phone and it's really microscopic. That's my fault.
Let me say that I do have one of your comments up here, and I have one of your comments down on page 18, I believe. In the same section, I wrote this verbatim after listening back to it multiple times. Insert a declarative statement that the use of private devices or accounts to conduct public business triggers records management, retention, and open records law, is what was said in the advisory meeting.
Yeah, now that is not, I think you asked me to send you something and I did send you something. I
Yeah.
think, I don't remember the word triggers. I remember implicates. I think if you look at your email, you'll find that I sent an email to that effect. But the reality is, from what I'm hearing, this discussion isn't going to lead us anywhere. I'm not willing to, this is an issue that's extremely important to me. And I feel like, I feel like there was an era when KDLA took a very strong position that the use of a private device to conduct the public's business implicated all of these laws. I will also say that I understand that that issue has been called into doubt by the opinion of this recent Attorney General, and a single opinion of an Attorney General on his last day in office. I can, if anyone's interested in the history, I can tell you the history of that opinion. But the bottom line is, we do know that this issue is now has a question mark beside it. But I will also say that Kate, in many instances, the Attorney General in that era, because we were dealing with this brave new world of email and texts, and listen, we were working very collaboratively with KDLA. Many of our cues we took from KDLA, and this idea of best practices needing to be somehow very beige so that we don't step on any toes. I'm kind of surprised by that, because guidelines to me should be best practices. They can be simple declarative statements. Draw your own conclusions. I'm not saying what Barbara said, because I do acknowledge that this issue is before the courts, but I am saying that, like I said, I won't die on the battlefield for this one, but I think it will be a less persuasive, less valuable guideline if it leaves that door so wide ajar. But that's just my view.
Well, thank you. This is a living document, and pending whatever decisions are made on the matter, we're going to come back to this document later. We're going to update it. So if it can reflect whatever is decided in the Court of Appeals or the Supreme Court later, right now, I want to get this approved.
No, I understand.
I'd like to make a suggestion.
Yes.
That we add to the end of this sentence something about to manage public records under current statute or law or records management, and something just at the end of that to indicate, as Amy has said, that there are implications for the current laws that are under review or under possibly will be changed, but it avoids the word implications, but it mentions the context of that statement.
I mean, I would be okay with under Kentucky law, if that's what you mean.
Yeah.
To manage public records under Kentucky law.
Yeah.
Yeah.
I'm good with that. Is anyone opposed?
Type it out so I could see it. I'm fine with that.
Okay. Are any of the voting members of the working group opposed to that? Okay. Like to move. Oh, yes.
Just a question. all the updates that you are adding today, when will we get a copy of this?
Yes, I'll send it out.
Okay, thank you.
Derek, what we're working on here is something that could possibly change. Is that correct?
Yes.
Could we say under current Kentucky law? Or do we need to be that specific?
I don't necessarily think current is necessary. I don't know if it adds anything. I mean, I think it's kind of always implied, the word current, when you're talking about law.
Yeah, I think I like it as is, but yeah, this is a document that we're going to have to come back and review regularly. So I don't mean all the time. I'm ready to get it out there into the world to help people. That is what it's for. And yeah, but I'd say annually or biannually, we could return to this and make it reflect the current landscape, the current law. So we had a couple other ones to move along. There were some questions about our definitions, which many of us were here for the creation of them. We borrowed many of them, rewrote them for our purposes. So agency staff was found was described as maybe a bit too vague. So one recommendation was every employee and official is responsible, because it didn't separate officials from the staff. And I'm in favor of that. I didn't put as much work into these definitions as some folks, but
The problem I have with that is the statutes basically seem to focus on the agencies. That was part of our discussion earlier. They don't define employees, they define public agencies. But when you say every employee is responsible, so that means if I'm a grade 9 employee at, say, the Department of Corrections, I'm responsible for everything in the Department of Corrections.
no, just what you create.
Just what you create. Okay, because there was one comment that said that they create, but a couple of the others didn't have that.
Yeah, I added that one to make
Okay.
it clear.
All right.
So with all of these, it would be all these worked in, it would be every employee and official is responsible for maintaining records that they create. If you were to work in all of these.
I think it would be every public agency employee.
Yes, yeah, it should be, to clarify.
I think the only reservation I would have, I think in theory it sounds fine, but at some agencies, you might have employees that are like doing data entry. They still have a few that do this. And they key that in and it goes into a larger system. So you have like grade 9, grade 10 employees. They created that record. They don't have any control over it. They enter it into a larger database that they don't manage anyway. So how can they be tasked with responsibility for something that they have no control over other than the original entry of the record?
Yeah, but any emails that they're firing off do need to be managed by them.
Emails, yeah.
Notes
I
for
would get that.
meetings. This is general advice. Basically be prepared. No one's going to jump in and manage your records for you. So basically it's just be mindful, and we do want 9s and 10s to be mindful of the fact that they are creating public records, even at their desk. I mean, no one is being told this, and that is kind of the baseline for good records management.
Yeah, this is not, and this is Amy Benson-Haver again, this is not a data entry guidelines. This is an electronic communications guidelines.
Yeah, we are trying to define preservation.
I agree with removing preserving and or substituting managing for preserving, because it's at every level. I mean, if the record is less than a permanent record, it also needs to be managed.
Or maybe just add preserving appropriate records. That way it's clear that we're talking about the preservation of records that require preservation.
Well,
Yeah, because they're supposed to delete spam immediately, right? So they wouldn't want to preserve spam.
Right.
yeah, I mean, what about management, retention, and destruction? I mean, these are terms that are more directly associated with that function of preservation of records. Of course, I've heard all sorts of discussions at KDLA about this kind of grand process of preservation and the ability from, as systems change, that they be preserved through the system changes. I think management, retention, and destruction, because again, that is exactly what we're dealing with in this context. So spam, yes,
Yeah.
delete it immediately, get it out of your system, retain those that need to be retained, and manage them appropriately in folders or whatever way you look to make them accessible.
And that is far less vague than saying preserving, maintaining, or managing. I think manage, retention, and destruction is a fine choice for this definition. It's addressed throughout the document and other places. It's just more clear. So
I would think, though, that we're talking specifically about preservation, which has, we're trying to define preservation, which has a kind of different meaning than managing.
it does. It can be viewed as certainly part of it, as sort of a part of the bedrock of managing it. You have to have preservation in place.
Might I suggest we say including preservation?
But the definition is preservation.
I would also point out a 9 or a 10 is never going to have anything considered official correspondence, setting policy for an agency. They're going to have, general correspondence at best, which is up to 2 years, not keep it for 2 years.
But Jeremy, isn't the idea that they still would be responsible for ensuring that for whatever period of time those records have value, even if they are routine correspondence, that they are preserved, retained, managed so that they are accessible? Yeah, I mean, regardless, very few of us, at least in my experience as an assistant AG, I created very little official correspondence, but I created a crap load of general or routine correspondence.
Yeah.
So I still felt an obligation to manage those records, retain those records, even if it was an up to 2 year retention. It's just not like random destruction. I mean, while those records have value to the user, they should be retained. But I hear what you're saying. Listen, again, these are ways of trying to trying to establish greater clarity here. I think the efforts of KDLA in this regard are commendable, and I don't want to stand in the way. And I don't think that the advisory wants to. I can't speak for everyone. I'm confident no one wants to stand in the way. It's just we were trying to introduce clarification, points of clarification that might be useful if they're unacceptable. Again, it's guidelines, we hope they're the best they can be. It's best practices. We hope they're the best they can be. And we want to promote responsible records management.
Yeah,
I think we're we're taking the definition of preservation as only applying to long-term records or permanent records. And it could be broadly interpreted as preserving things at the appropriate to the retention schedule, to, you know,
Could make,
maintaining or preserving or managing according to the schedule.
that was going to be my suggestion. If the hook here is to just use preserve and manage in connection with the records retention schedule, and then it's going to be the record retention schedule that declares how and the length of preservation.
I'm going to disagree because then we have a different definition for records management. So we have two different definitions, preservation and records management. Records management is addressing that a public agency must have a records management program. We can include staff should be responsible for records management, but preservation, I think, is very specific to preserving of long-term records.
or short term, like Lynn said, it's I mean, honestly, it's more technical in nature if we're going to talk about digital preservation in this manner. Do we have, we don't have to preserve our emails in that as long as you don't delete them, they're probably going to be fine. That's COT's business. When it comes to making sure they're recoverable, make sure it's a file extension. Like when I go out and do trainings and touch on preservation, we're talking about some things that you have control of, some things that your IT infrastructure has control of. And that comes into play very much when we're looking at the policy memorandum for iReadable exemptions. We have to get to the bottom of it. Generally, if it's a COT managed IT environment, many of those are checked off immediately, but sometimes if they do their own and opening it up to local government, like redundant copies, make sure your storage media is migrated, make sure your file formats are migrated forward into something that can be opened and recovered. That's actually digital preservation. That is possible in the local within the agency. So that is what I go out there and preach. Is this the venue? Is this definition where we get into it? I don't know. Maybe I'd like to have enough there to give them a sense of that. But it essentially just says preservation. You're somewhat responsible for preserving your records. It doesn't actually say what it is meant to be. We point to kits. There are some ideas of what to look for in kits. If you look for it, there's a digital preservation section in kits. So maybe we point to that if we're going to point to anything. Maybe that would be an answer. Because I don't know if we can write a treatise about what actually is involved in digital preservation in the short definition.
Could we compromise and get the word managing in there and imply by inserting the records retention schedule, which also includes permanent or long-term records, or somehow saying that it gets more difficult the longer the retention period, and additional methods need to be imposed. But there again, you're saying we don't want to write a treatise about preservation here.
Having something to point to, though, a URL, something to click on would be, seems like a good way to go.
Yeah,
What about something to the effect of every public agency, employee, and official is responsible for preserving the records that they create and use so that they may be maintained in accordance with the agency's record retention schedule.
I like that.
Very good. And then I'd still, now that I've hit upon it, I'd still like to link to something that, a longer piece on digital preservation.
Yeah.
It's just me, but yeah.
Well, I want to say one thing sheepishly. I would like to say that I now agree with Catherine. I actually see that it's not visible on the screen. Sorry, but I will say that there is a separate definition for records management. And in that context, because again, I have a notion from my years of working with KDLA of preservation as being something that is handled at a higher level. Records management is handled at an individual employee official level. And so actually, I'm kind of on board with, for what it's worth, because it's worth nothing. I see Catherine, at least I want Catherine to know that I see her point. And I think I agree with her that for the definition of preservation, we don't need to get into the employee's duties or the official's duties to manage his or her own. You're welcome. Yeah. So, because it's a good point. It's just not visible on the screen, but there is a section that defines records management, records retention, record series. But anyway, that's just, I see her point. Absolutely.
I think preservation is worth at least telling them about. And like Glenn said, it's expected that these be preserved for the duration of their retention. It happens to be the same amount of time. I like what Mark pitched. And then so I mean, I of course agree it is different than records management, but it happens to work alongside it. It needs to be, and I mean, people run into preservation issues. If you could be a 9 or a 10 and take photos for an agency event on either your or another phone or an agency phone, and you're going to want to first of all get those off that phone, and then make sure that they are a format that can be opened, that can be preserved. Make sure that they're, I mean, same could be said for other files off your phone, but just generally, it needs to have software. You have to have software available to open it. So don't create something that you can't access. And that's kind of a tenet of digital preservation. Were you going to say something, Mark?
I was just going to say, I mean, a definition can refer to another definition. The fact that there's another definition somewhere else doesn't mean that we can't use the word here. I mean, public records don't exist but for public agencies. Like, it has no meaning unless public agency actually has meaning. So, I mean, the fact that we might reference management in this definition, if anything, would clue them in to go read what management means in the definition section without having to restate it here.
Yeah, you could like add something at the end for temporary or short-term records, see records management or something like that. And then you can include a link to kits in the definition for preservation system.
So it's every public agency employee. And then wouldn't it, I think I said, so that they can be managed in accordance with the records retention schedule. It sounds to me like the act of preservation is to like save for the moment And then management is like how long the moment is and where it goes.
Yeah.
sort of, right? Like, so you can't manage something unless you have first preserved it.
Yes.
For what it's worth, my impression was preservation was long-term preservation beyond the lifespan of the public official, the public employee. If official correspond, and once the official who created the official correspondence leaves state service, that record still would have to be preserved as a public record, official correspondence for a permanent retention, with preservation mechanisms in place to ensure that through changes in technology, changes in systems, it is available for in perpetuity.
Yeah.
That's a preservation to me has a longer connotation than records management and retention, although some records are permanent records. To me, preservation subsumes that.
Well, that is the connotation because you hear about that most, and that's when it is arguably most vital, but you also don't want to lose your shorter term working file.
Right. Absolutely.
So both views of it are correct, and both are a real concern. We deal in long-term permanent digital preservation in our branch in electronic records here at KDLA, but we go out and those same principles apply to any record prior to reaching its retention.
Should it be with the public agency's retention schedule or that public agency? Because they don't all have the same retention schedule.
Oh, I know.
Yeah, manage in accordance with the public agency's retention schedule.
And the general schedule.
The applicable.
Yeah, applicable retention schedule.
Yeah, I like adding the applicable just because sometimes we do borrow from other ones before. Like I know Lexington has in the past borrowed from other retention schedules, but because we didn't have it on ours and then later on commissioned to put it on ours.
Mm-hmm. Well, I know we have please contact KDLA for preservation guidance. I'm not going to do it live here because I'm going to have to find it, but at minimum, I think we could make the contact thing point towards KDLA's page. I'd like to point it towards an explanatory document. I'm going to make a note here and just highlight it.
Derek, is there a preservation guidance document or like guidelines for preservation document? Oh, is there a document on preservation guidance, or is that just something you all provide orally or through regulation? Or
it is mostly something we provide in trainings. There is a preservation of, it's a long title, of digitized materials that really does cover a lot of the hallmarks, but it's not generalized. It's more about digital images.
Okay.
That is on our webpage. Yeah, when fairly soon we're actually going to be recording on-demand trainings, which will help us reach a lot more people. We're working out the software and licensing, but I'm going to do one on preservation on both levels, on the for the long term and for what you can accomplish yourself in your office, because people do have questions about that. So those will be forthcoming just from electronic records branch. However, I don't think we have a nice fully detailed document on preservation that is up to date. And share and on the webpage.
It's not addressed in regulation or anything like that.
That I'm not sure.
Do you know, Glenn? Do you know, Glenn or Catherine? Do you all know if there's like any reference to preservation in the regs?
Only in a general way, in that it's
Okay.
one of the categories in for preserving or managing records.
I gotcha. Okay.
Okay, I'm sorry, this is really annoying and I apologize in advance, but is there any way that we can make sure that all the paragraphs are justified instead of left justified? So that they look the
Oh,
same?
yeah, right.
Yes, we can format it better.
Yeah, like the PI is fully justified and it looks a lot better than the left justified.
Yes.
I used to get dinged for that all the time as a young lawyer and it annoyed me. And now I'm the one dinging people. So I understand it's annoying when it gets brought up.
Yeah.
And this is a download of the Google Doc, which presented its own problems in that transfer. And it's gonna be a nice shiny PDF once we finish it. And I mentioned this in the advisory, but all of the headings, this is going to be fully mapped out and clickable. And it is when you in Google, and Google will preserve that when you save it as a PDF. The Google Doc will preserve all that. When you make it a Word doc, which is easier to share and mark up with comments for those who are not in the Google environment, everything gets wonky. So we will make sure it is well formatted, and I think equally important to me, clickable. So local records can click on their sections, jump straight to it. If you're only interested in social media, you can click on section 3 and it'll take you right there. So that's the goal. But yeah, thank you. And that will be noted and fixed. So I was going to
Okay.
dig
We're
through
down
some
to
stuff.
preservation.
Yeah, we can go back to preservation. Outside, after the meeting, I will locate something and have that ready for you all. At minimum, by next meeting, I am going to send this marked up document to every member of the group, as Tammy requested. So I think we'll all be up to speed on where we are with this. We have about 9 minutes left. I think we made some good progress here in preservation. I'm going to insert a hyperlink either to our general website where they can contact KDLA, or include a link directly to a document.
Derek, would it be okay if you send a copy of the revisions that have been made to me today? Can you send one of those to me as well?
Yeah.
Thank you. Thanks.
And send it to Jim as well. I think he's still with us.
Yeah, please.
Yeah. This is a simple one, and said in government offices, I think by public agency employees. That's more in line with what we said at first.
I would leave it to just public agency. I mean, if you have a private entity that becomes a public agency, but then they hire a contractor and then they do something, like, they're not going to be
considered.
So I would just use it as public agency.
I would like to say by public agencies, because it's created and maintained by.
Yes.
Oh, I cannot type today. Okay.
Can I just say one thing about that? I'm sorry. I know you've already scrolled down, but there have been instances, there have been appeals in which open records appeals in which public officials and employees. There's a case involving a UK professor who basically transferred all his public email to his home account. I mean, these were public email. I mean, I guess that's the problem. If they have to be on site, this is going to be a problem. This, again, this is where, of course, Mark and I probably differ, but this idea that a record can be possessed for and at the instance of a public agency. The case going back to the early 90s involving the city of Louisville's public pension fund pension fund and its financial advisor. So it's a case that got cited for many, many years, Cullinan versus city of Louisville, I think, or I forget, that firefighters fund or something. Bottom line is, listen, this is nitpicking, but I will say that is problematic because it does suggest, it creates the possibility of an official or an employee thinking that by removing them from his public office, he has changed their character. But that's, and this is again a recurring issue across the United States.
Well, all we did was change government offices to
Right.
by public
Right.
agencies, and I
Right.
switched in. public
Right.
offices
No.
to by
I
public
hear you.
agencies.
Yeah, I hear you 100%. It's just, again, I think very much like someone who reviewed these appeals for 25 years, I kind of do understand where loopholes can be created and be exploited. And therefore, I think about that. And I've seen instances where that's been argued. A city attorney has records in his private law office that basically he holds for the city. They're not in a government office or a public agency, but they are held for the public agency. But again, I doubt that anybody thinks about this stuff quite as esoterically as I do, because I have seen so many. And again, for the period I was in the AG's office, I had to restrict myself to Kentucky law, but I am seeing these recurring issues across the United States. In some respects, Kentucky is ahead of other states. In some cases, we are lagging way behind. So that's my concern is, but again,
What in the document are you talking about? Are you referring to?
The last discussion about public agencies in government offices versus in public, again, it's a limitation, implied limitation that it's only if it's physically in the agency's office, and the potential exists those records might be removed either inadvertently or with very malicious intent to try to exclude them from the application of the open records or records management laws. But again, listen, let's move on. I just wanted to point that out. Language can be very loaded. And these are best practices. I get that. We hope that people will look at them with good intentions and not look for loopholes. So I'm sorry, Derek, I didn't mean to, I just want to point that out. It is somewhat problematic language, but
Let
that's
me-
cool.
I have a
Oh,
different
add one
question
thing.
here.
Go ahead, Graham.
We start the sentence saying employees of public agencies have a responsibility under Kentucky law. Now we're switching to public agencies. So to me, maybe I'm overreading it, overthinking it at this stage. But again, if you're one employee in an agency, you're not responsible for everything in that agency. You're responsible for your records. You're not responsible for everything everybody does. So I think we're changing our terminology in the sentence, and I think that can be confusing.
Okay, let's see.
This might be something to put a pin in.
So wouldn't it be created and maintained by them? Them referring to the employees? We either need to change the beginning of the sentence or the part where your cursor is now. I'm not sure, but to me, they're not lining up.
No, I'm with you. employees of public agencies have a responsibility under Kentucky law to see that information created and maintained by,
I'm just saying, like, if I'm a parole officer and I would be responsible for what I keep, but I'm not responsible for everything that the Division of Probation and Parole does, or everything the Department of Corrections does.
I think we were
No.
just trying to, as we did earlier, just trying to change government to public agencies, but I think it should be it probably should be on the level of the individual. So created, as we changed up above, we did change that to indicate that. We indicate,
Just so we're consistent there. It
Yeah.
just seemed, like I said, I could be overthinking it now, but it just seemed a little inconsistent just to switch from talking about employees to agencies in the same sentence. That's all.
no, yeah, having zoomed out and read it as it reads, I think it helps for context too. Is anyone opposed to that, to saying created and maintained by them or themselves? Public records as defined are organized and accessible, because that is the role that we're trying to drive home.
Would it be to see that the information, I prefer records. Information is kind of a nebulous thing, but to see that the records they create and maintain dash public records is defined by KRS A2, another dash,
Yeah,
are
that's good.
organized and accessible for use.
Yes, I think that would work.
I'm going to put it on the page just so we can see it. I'm not records.
They create
and maintain. And take out by, because we already have public agency.
Yes.
Are accessible and organized.
I'd put another dash after 2, so it's like a double-sided. Like the M dash.
And a little nitpicking thing, I would move the paren 2 against the 870. I know Microsoft tells you it's wrong, but when you're citing the statute, there's no space between the number and the subsection.
Like so.
All right,
Yes.
like that. Thank you.
I think that reads a lot better without losing anything. Does anyone disagree? I think it only clarifies it.
I agree. It clarifies really well.
Thank you.
I think it's a good place to stop.
I think that's a great place to stop. I'm going to do some work on this. I will send this out probably immediately. Any recommendations I have, any further recommendations I will bring up at the next meeting, but I will send this out to everyone, and I will send out a record we referenced much earlier in the meeting, the electronic signature record keeping. I will send that out to you as well. So I'm going to go ahead and move on to the next item because we're running out of time.
Derek, I'll have to jump off here. I have a hard stop at 11:30, so I just wanted to let you know that. But thank you, and I look forward to receiving this document in the email. Thank you.
And we do still have a quorum, so briefly, does anyone have any agenda recommendations for the next meeting? Okay, do we have a motion to adjourn?
Motion to adjourn.
Do we have a second?
Seconded.
Second. Yeah, go ahead.
All right, well, we will consider this meeting concluded. Thank you all very much for coming and for the lively discussion. I think this was a very productive meeting. So we will see you next time, May the 10th, because most of us, or a lot of us, will be at the Kentucky Digital Government Summit. That's why we have the strange date. But I think if enough people RSVP'd to attend next time. So I appreciate that flexibility. All right, thank you all.